So we need to talk about two Supreme Court decisions, one of them which was a unanimous decision, which impacts your right to prevent the unlawful search and seizure of firearms within your home. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Firstform. Firstform's an amazing company. You know, if you're looking to get healthier, work out more, they have amazing supplements, plus they're pro-freedom, pro-Second Amendment. So again, if you're interested, check them out using the link down below. And if you order something $50 or more, you can get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be discussing Supreme Court cases, one of them which was a unanimous ruling, which involved the warrantless search and seizure of firearms within a home. And the other case deals with the community caretaking exception, which ultimately resulted in police not only threatening to hold an individual indefinitely, but then also threatening to keep his firearms forever. The cases we're going to be talking about in this video are called Caniglia versus Strom, and then also Torcivia versus Suffolk County. These cases should be on everybody's minds because they involve when law enforcement can use legal workarounds not only to enter your home without a warrant, but also confiscate your firearms without a warrant and potentially keep them forever. Now, the facts surrounding the Torcivia case are very interesting. Mr. Wayne Torcivia was a 57-year-old man with no record of violence and no history of any issues, no depression, no mental health issues, nothing in his history that should have resulted in this type of incident. Early in the morning of April 6th, 2014, his teenage granddaughter called social services complaining that her grandfather was yelling at her and acting weird. And at no point did the granddaughter claim that he had assaulted her, that he had a firearm, or anything like that was involved in the incident. Following that call with the granddaughter, they then called the Suffolk County Police Department, who sent 3 police officers to his home. When the police officers arrived at his home, they all agreed that he had not committed any crimes, that nothing really was going on, and that the granddaughter was potentially just acting irrational. However, at one point during the discussion in the conversation with the police officers, Mr. Torcivia and one of the officers kind of had an interesting kind of disagreement. One of the police officers kind of turned slightly and then accidentally knocked down one of the magnetic drapes that was on his, front door. I know a lot of you probably have, magnetic drapes on your front door for bugs and stuff like that. And so the police officer knocked that off the door. Now, Mr. Torcivia went to go reach down, pick it up. And at that point, the police officer screamed at him very loudly to get back and then threatened to tase him if he didn't get back. Mr. Torcivia claims that he then responded to the police officer and he said to not tase him, "Please don't tase me. I have a heart condition and I could die." But the police officer alleges that he heard that Mr. Torcivia say that he wanted to be tased and that he wanted to die. And because of that miscommunication, Mr. Torcivia was then arrested and placed on psychiatric hold. And from there, all of this starts to spiral out of control. After dropping him off for psych evaluation, one of the police officers did a computer check and they found out that he had a New York State pistol license and that he also had some firearms within the home. The police officer then contacted his sergeant, who then instructed that police officer to ask Mrs. Torcivia, his wife, to essentially give up all of those firearms. However, at that time, Mr. and Mrs. Torcivia both denied the police consent to confiscate those firearms. But eventually, his psych evaluation came back clear, about 12 hours later, and the hospital there recommended him to be discharged. However, the social worker at that point got involved. They also found out about the permit for the pistol license and then also the guns being within the home. And at that time, one of the interns was contacted and they said that they wanted to get control of those firearms, that they wanted the combination to the gun safe. And there was some back and forth. And eventually what ended up happening is Mr. Torcivia and his wife were told that he would not be released from his psych evaluation hold, that he would not be released pretty much indefinitely unless he gave up those firearms. With the threat of potentially having to remain on psychiatric hold and being in the hospital there pretty much indefinitely unless he gave up the firearms, he eventually consented to giving up the combination of the safe and the firearms. So those are the basic facts surrounding this case. This issue spiraled from a baseless call from a teenage granddaughter all the way to him being held in a mental health facility and then threatened to not be released until he gave up his firearms. Also keep in mind, all of this was done without a warrant, and he still has not received his handgun back. Now, this case made its way up to the Second Circuit Court of Appeals for review, and on review, the Second Circuit found that the police could actually do this under the special needs exception to the warrant requirement. Now, in coming to that ruling, the Second Circuit largely ignored a prior Supreme Court unanimous decision in the Caniglia versus Strom case. Now, if you're not aware, the Supreme Court has issued a unanimous ruling in a case called Caniglia versus Strom. That case dealt with whether or not the community caretaking exception to the Fourth Amendment actually applies beyond vehicles and could extend to the warrantless search and seizure of potential firearms within your home. Now, relevant for both of these cases is a 1973 Supreme Court decision called Cady versus Dombrowski. In that case, the Supreme Court held that the police officers had not violated the Fourth Amendment by searching without a warrant the trunk of a car that was towed after an accident, because that was part of the officers' community caretaking functions. The court found that the warrantless search of an automobile under those circumstances could be constitutional. However, going back to this Caniglia case, the Court of Appeals held that the community caretaking exception to the warrant requirement could also apply beyond vehicles and could also apply to searches within the home. Caniglia in that case made its way to the Supreme Court, and the Supreme Court on review issued a unanimous decision in favor of Mr. Caniglia against this type of action by law enforcement. Now, Justice Thomas actually wrote the majority opinion, and in writing that opinion, he stated that what is reasonable for vehicles is different from what is reasonable for homes. Cady acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit the warrantless entry into the home. Now, based on this, the Supreme Court unanimously found that the warrantless entry into his home and the seizure of Mr. Caniglia's firearms was in fact unconstitutional. Now, going back to the Torcivia case, which came after the Caniglia case, in Torcivia, the petitioners asked the Supreme Court to reverse what the Court of Appeals said because it outright refused to meaningfully apply that Caniglia analysis. The government argued that Caniglia did not apply at all because Caniglia dealt with the community caretaking exception, and they argued that this case, Torcivia, dealt with the special needs exception. They stated that the petitioner's argument that the appellate court merely rebranded the community caretaking exception as a special needs exception is unsupportable. The special needs exception to the warrant requirement has been recognized by the Supreme Court and other courts in very limited scenarios. These include searches conducted by, Border Patrol at borders, searches within prisons, airports, students and potential employee drug tests. So in very special situations when it's not traditional law enforcement functions, but something else, just broad-reaching application of some sort of search, again, within airports, it's not part of traditional law enforcement functions, that could be permissible. Now, in contrast, the community caretaking exception to the warrant requirement includes caretaking activities performed by law enforcement officers that's outside and not related to the detection, investigation, or accumulation of evidence related to the violation of some sort of criminal statute. So the argument by the government was that the special needs exception and the community caretaking exception are too far apart for Caniglia to actually apply to the Torcivia case. Therefore, they argued that the Supreme Court should not review the case at all. And ultimately, on review, the Supreme Court agreed with the government and denied the summary reversal of the case and decided to not review the issue. Therefore, they issued an order denying cert in the Torcivia case. Now, whether that was because they believed Caniglia did not apply to that case or that situation, or because the petitioners did not properly plead the issue of an unlawful entry into the home, we really don't know. We don't get an analysis from the Supreme Court about why they deny cases, but unfortunately, now that sits as precedent in that Court of Appeals. Now, these cases are important because they deal with your protection against the search and seizure of firearms within your home without a warrant, under those loose government rationales like community caretaking or the special needs exception. These loose exceptions are being used more and more by law enforcement and also by certain states and government agencies within the states to enter homes without a warrant to confiscate firearms. This becomes even more important as many states will now move even more aggressively to try to do things at a state level as far as gun control and push more broadly for red flag actions and things like that. And that's really because the Trump administration is taking down a lot of the Biden, anti-gun regime that they put in place. And so a lot of states at the state level are going to be even more aggressive in these types of actions. So these are some very critical Supreme Court decisions that you should be aware of as a gun owner to protect yourself, and just know about some of these exceptions that exist that are being used to unlawfully enter into your home without a warrant and potentially search and seize for firearms. So hopefully you guys found this information helpful. If you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.